Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to Building the Bridge. I have the honor of being today with Elliot Alderman, who's an IP and tech attorney based in Washington, D.C. Thanks for being with us, Elliot.
Hi, Steve. Glad to be here.
So we work with a lot of foreign national entrepreneurs, creatives, as well as companies. For those individuals and companies that are launching or thinking of launching in the U.S., how do they protect their trademarks and copyrights?
Okay, let me start with copyrights because those are probably easier. Unlike trademarks, copyrights you get by fixation, which means that you put it into tangible form. So you can get it based on use, but really to enforce it, you need to register it. There's exemptions or exceptions for foreign works, but one of the benefits of registration is statutory damages, and you can't get that even for a foreign work unless you have a registered copyright. So it's worth going through the process of registering. And depending upon licensing agreements, if you have a subsidiary and the subsidiary owns, it's a US subsidiary, and they own the copyright, then you probably would have to register it anyway. But I think the better practice to get the benefit of statutory damages is that you go through and register it.
Okay, let me just jump in for 1 second before you tackle the trademark.
Sure.
For somebody who does not understand what the landscape looks like legally in a common law country like the US, and without going into too much detail, what do you mean by statutory damages?
Okay, the two really big benefits of registering a copyright is that you get attorney's fees and statutory damages. Copyrights are strict liability. It's a tort. So the plaintiffs are in a far better position than a defendant. And what statutory damages means is that unlike actual damages, which you do have the option of either actual or statutory damages, but statutory are easier because there's a range from $750 for innocent infringement, and this is per work, up to $30,000 per work, and then $150,000 for willful infringement. But statutory damages means essentially that even if the work is worthless, the plaintiff bringing the action doesn't have to prove damages, and often judges will split the difference and award $15,000. So there are situations where works that really don't have a market can get that much in statutory damages. And attorney's fees are usually very, very expensive for IP infringement. It's very fact specific, and proof of facts is very expensive. So that's another reason that people want to have statutory rather than actual damages.
Okay, got it. Well, let's go on to trademarks then. What should people do in terms of protecting their trademarks?
I recommend for both of them, but particularly for trademarks that people register them. I have several cases now where in the United States, it's a first to use as opposed to a first to file jurisdiction. And you can get a trademark based upon use. It's called a common law mark. But again, because proof of facts are so expensive, the benefit of registering is huge because it gives you a prima facie case that you have use throughout the United States, where, for example, if you had a common law mark, you'd have to prove factually where you're using the mark. And generally, those are smaller companies and individuals that don't do it. And it will be so much cheaper for them. And this is a situation that I have now with two clients where they're going to end up rebranding because even though I think they have priority and they could establish some kind of concurrent use right, they don't have the resources to do that. So if they had spent a couple thousand up front and gotten a trademark instead of done it based on use. I guess that's the definition of penny wise and pound foolish.
You just took the words out of my mouth, actually. Elliot, I was going to say that one of the recurring themes that I've encountered in my practice in the last 20 years and the other professionals that work with foreign nationals that are launching operations or products or services, or even things like the things that you work with that are trademarked or copyrighted, that they don't want to spend the money up front, and they end up having to spend obscene amounts of money in the end, or they go broke, or they end up in litigation, or they have to rebrand. I mean, how many of these horror stories do we need to tell before people say, you know what, part of my operating budget or my startup budget is going to be prevention and going to be registering? It sounds like registering is a no-brainer, isn't it?
Yeah, I think that's right. And I think for the compliance issues that startups often, they look at tangible things like paying rent as something they can, it's very clear to identify that. They don't look at downstream risks because they're abstract. And there's probably a standard bunch of things that I would recommend for a startup or a foreign company in the United States. And if it costs you $5,000 or $10,000, that is a very good business investment, because if you subsequently have litigation or there's a problem where the state or the government comes after you, it's quickly going to be tens of thousands or more in potential exposure. And it's unnecessary to do that.
Sounds almost like we sold it as sort of upfront insurance that people understand how useful it really is, right?
Yeah.
So if you're a creative or you're a foreign company, you're thinking of launching operations in the US, and you would like to register your copyrights and trademarks and have somebody navigate that path and come up with a strategy for you, how would they get in touch with you, Elliot?
I'd be very happy to talk to them. My phone number is 202-596-5682. My email is Elliot, ELLIOTT, @thecontentlawyer.com. And my website is www.thecontentlawyer.com.
Fantastic. Thanks for all your knowledge today and for your time, Elliot.
Thanks, Steve.